Still got about 5 feet of snow up there, Casey?
Just about. We got about another 6 inches today, so over 1.5 feet last weekend when you guys were getting it with ice.
Yeah. We were lucky in Grayling comparatively. We're basically everything was shut down for about 2 days, but they're talking weeks and weeks for Gaylord.
Yeah. Our office has power, but we still don't have internet, so our server's been down and I haven't been able to send or receive emails since it started.
Oh, God.
You've tried to email me in the last week. I haven't received it.
I did. I emailed you on Saturday, as a matter of fact, but that's okay. We'll get through the status conference.
All right, council, are you able to hear me okay?
I am, Your Honor.
It's quiet, but maybe it's my old ears, Judge.
All right, I'm having a problem with the camera. I'm not sure why that's not on. Hold on 1 minute here.
There you are.
All right, here we go. Thank you. Okay, we'll go on the record. This is Northern Mutual versus Prather, file number 2419867. We have everyone present here today. Mr. Ryman is not present, but this was set for hearing at 1:30. I apologize for the delay. We have one operational courtroom here in Otsego County right now, so we've been juggling with other judges who need to get time-sensitive hearings taken care of. So that being said, we are set for a status conference in this case. If I could just have counsel put your appearances on, starting with plaintiff.
Casey Majestic on behalf of the plaintiff, Northern Mutual.
William Carey appearing on behalf of the Prathers. Just note for the record that Ms. Prather is appearing to monitor the Zoom call.
Okay, thank you. I guess starting with plaintiff, Mr. Majestic, where are we at right now? I know we had a hearing not too long ago.
We've had some settlement discussions, Your Honor. My read of the situation is that it's going to be impossible to settle this case if we're not all in the same room talking at the same time. I mean, it could be a virtual room, but I've had a number of different settlement offers with different terms crossing. So I think that this would probably be appropriate for facilitative mediation. Additionally, I know that the motion deadline is today. I'd ask that that be extended out past facilitative mediation because we'll probably file a motion if that's not successful.
Okay, Mr. Carey.
Well, I'm saying this as much for my client's benefit as anyone, Your Honor. In the underlying case of Ryman v. Prather, Gretchen Olson served as our mediator. She's a good mediator. We spent about 10 hours trying to mediate the case. And we weren't able to come to a resolution. As Mr. Majestic is not so subtly suggesting, the goalposts keep moving. And that makes settlement discussions difficult. I know the court favors facilitation. I favor facilitation as a general rule. I feel very badly about the amount of money my clients are spending to not so much this case, because I think Mr. Majestic has been prudent, with the court's time, but in the underlying case. So that's my only misgiving. I think uh, maybe what we do is schedule a mediation, book it for a couple hours and see where we get. And if we're not getting traction after a couple hours, then I'd favor bailing after that. I know that's a very dismal approach to take to mediation, and it's not the one I usually um, project.
All right, and the underlying litigation in the other case, this part of it is on hold, right? Your client's part?
Yeah, it's a little confusing. I think I'm not sure that this is not meant to be critical. You know, I love your staff, and I think they do a tremendous job. I don't know if they recognize that the stay applies to Ryman versus Prather and not Ryman versus Johnston, although I think the order was pretty clear. According to Ms. O'Rourke, the clerk's office has treated both cases as being on stay, and that's created some confusion. Fortunately, there is no motion practice pending in Ryman versus Prather. So we've got a de facto stay.
Okay,
Does that make sense? I hope.
yeah, it does. Yep, I understand. Okay, so I guess what I'm hearing here in terms of scheduling in this case is set this out for a period of time for the parties to attempt mediation. If that's not successful, then Mr. Majestic, you'd like a cutoff date for motions to file.
Correct, Your Honor.
And I know Ms. Prather and Mr. Prather
It's-
really want to express their views in this case, and it may well be that a facilitation serves that circumstance the best.
Well, what's your counsel, both of you, what's your suggestion for a time frame for mediation? And then Mr. Majestic, what would you like to suggest for a cutoff date for those motions?
Your Honor, how about 90 days for mediation? I've had difficulty getting mediation scheduled on a short term. As far as who to use for mediation, I've never used Miss Olson before. I'm open to her, but it sounds like she wasn't successful before, so I'd suggest Tom Cooper, a Plunkett, and Cooney. And I don't have a problem with some sort of time limitations for mediation, so it doesn't take up too much of the Prather's time if it becomes obvious that it's not going to settle in maybe 3 hours or something.
I know Mr. Cooper. He's mediated matters for me before, and I'm completely comfortable with that suggestion.
Okay. So we'll have Mr. Cooper selected as the mediator. And then 30 days after that, Mr. Majestic as a cutoff for filing motions.
Yes, Your Honor.
Okay.
Your Honor, I don't know how this is possible. If it is from a technology standpoint possible, my client wants to communicate something to me now. Would you tolerate her sending me a text with her question?
Well, I can put the two of you into a breakout room if you want.
Wow, that's impressive. Yeah, that'd be great.
Well, it hasn't worked yet, so let's not get.
All right.
I'm certainly going to try, so
We won't, I promise we won't be long.
that's fine.
Thank you.
Sure. Okay, here we go.
Yeah. Thank you, Judge.
Okay, Mr. Carey?
All squared away with everything that we've made a decision on so far.
Okay, so I will put what we've discussed into an order. I'll get that out to the parties. I'm also going to set this for a status conference at that motion cutoff date, in case there are no motions filed. Obviously, if the matter is resolved prior to that, the court will receive notification of that from the parties. And we'll go forward from there. Mr. Majestic, anything else I can address for your side today?
No, Your Honor, thank you.
I have two questions, I guess. I'm a glutton for punishment. Mr. Majestic, I just learned is without the ability to receive email, and I sent him some recent emails. Casey, what's the best way for me to get a communication to you?
Telephone right now.
Telephone. I'll do that. If you're available right after this hearing. And Judge Mertz, it looks like our case, that is Ryman versus Prather, got noticed up for a status conference at 3. Can I assume, recognizing the stay in place, that I don't need to be concerned about that?
Correct.
Thank you so much. Okay, those are my two questions.
Okay, very good. Thank you. Parties on this file are free to disconnect at this time.
Thank
Thank
you.
you, Your Honor. Have a good day, everyone.
You too.
Thank you.
Thank you. All right, Mr. Greenblatt, are you able to hear me okay?
Yes, Judge.
Okay, and you're signing in on the drafts matter?
Correct.
Okay, 1 second. Ms. Schaefer, can you tell me what file you're signing in on?
Yes, Your Honor. I'm signing in on drafts representing the defendant, Kenneth Drafts.
Okay, so we're on the record now in drafts versus drafts file number 2419738. You have Mr. Greenblatt here on behalf of plaintiffs, Ms. Schaefer here on behalf of defendants. So I was looking at the file. Counsel may be aware, I'm not sure where you're both based out of, but we were closed all last week due to the state of emergency. So I don't have any filings since January. This is set as a status conference here today. So maybe Mr. Greenblatt, and I'm saying that because I don't know if there was things that were filed in the past week or so that haven't made it into the file yet. So Mr. Greenblatt, can you tell me where we're at with things and what we need to do moving forward here?
Certainly, Judge. And I spoke with Ms. Schaefer about this, I think on Thursday or Friday. I'm going to request from the court, with your indulgence, an additional 21 days to determine whether or not we are going to file an amended complaint or proceed as is. The delay is as a result of a series of medical issues that arose in my household. You can't make this stuff up. In celebration of my 60th birthday, tooth extraction, broken nose, bashed up foot, and then a split arm. And that was before my son got sick. So my apologies. I'm hoping with the court's indulgence, you would consider allowing an additional 21 days to make a decision as to whether we're going to amend the complaint or not. I'm also looking for my client if they have additional information that would make an amended complaint appropriate.
Okay, Ms. Schaefer?
Yes, Your Honor. I don't have any objection to that. I have talked to Mr. Greenblatt, and he certainly has suffered through a series of unfortunate events recently, and I fully understand that. And so I think it'd be appropriate to give us just a little bit more time if the court is willing to do that, because it may actually perhaps hopefully resolve things and certainly narrow down the issues to what they should be if it's going forward.
Okay, so we've kind of been treading water since January, and maybe for good reason. If again, I'm sorry to hear about those issues, counsel. But in terms of moving forward, though, once there's a decision made and the complaint is either amended or not amended, next steps after that. Did the two of you want me to get this, build in some time here for discovery and get a mediation cut off? And then what I would do probably is then set this for another status conference at the end of that mediation cutoff period. Obviously, if the parties settle either on their own or through mediation prior to that, then we can take that down. But as an initial period here, if we build, time in to amend the complaint or not, and then maybe 90 days after that for mediation and discovery, and then set this for a status conference at about 90 days out with the idea that mediation will have occurred by that time. Mr. Greenblatt, do you have any objection to that?
I do not. I think that's very reasonable. We ultimately want to move the case along towards either a voluntary resolution or some sort of dispositive decision or decision on the merits by Your Honor.
Okay.
I also think
Schaefer?
that's,
Some sort of settlement.
Your Honor, I also think that's a reasonable resolution, very good way to handle the case.
Okay. Do the two of you think you'll be able to agree on a mediator?
Yes, I don't think we'll have any difficulty with that, Your Honor.
Okay, so I'm going to put that mediation is to occur within 120 days. So that'll build in time for plaintiffs to decide about the amendment. Parties to agree on a mediator and notify the court of your selection within 30 days. And then mediation to occur within 120, and then I'll set it for a status conference at 120. Mr. Greenblatt, any other dates that I can address for your side?
No, I think that's appropriate. And if the court sets a specific date, well, obviously myself and adverse counsel will discuss just to make sure we don't create a scheduling conflict for one another.
Sure. Ms. Schaefer, any other dates I can address for your side?
No, thank you, Your Honor.
Okay, I'll put all this into an order that'll go out to the parties along with notice of the date and time for that next status conference, and you're both free to disconnect.
Thank you, Judge.
Thank you, Judge.
Okay, counsel, we'll go on the record in TVF Financial versus 45 Degree. This is file number 2319505. If I could just have counsel put your appearances on.
Thank you. Good afternoon, Your Honor. Daniel J. Fico appearing on behalf of plaintiff TVF Financial LLC.
Scott Norton on behalf of defendant 45 Degree and Dean Bach.
Thank you. This is set for a status conference today. Mr. Fico, on behalf of plaintiffs, can you tell me where things stand at this point?
We did recently receive an answer that was filed on behalf of the entity defendant. So that's the most recent development in the case. That's the only contact I've had with from Mr. Norton.
Okay, and what are your thoughts or suggestions for scheduling going forward here?
Well, we've tried a couple times now to have this decided on a summary basis. I suppose the next thing would be to set it again for trial.
Judge,
Okay.
will I make a proposal?
Sure.
I'm sorry, Mr. Fecko. What is the totality of your claim absent legal fees and costs? I think it's somewhere around 30 grand.
It's just inside of the circuit court jurisdiction. I would say that $26,000 or $28,000, somewhere in that league.
And I know, Your Honor, and no disrespect to Gaylord, but my opposing counsel and I are probably a driver and a 9-iron away from each other. And I'm suggesting whether we facilitate, mediate, arbitrate this claim.
I mean, I think that's a matter between you and Mr. Fico. You know,
I did invite from Mr. Norton some months ago to see if his client could come up with some kind of a nominal offer in light of the what both sides will anticipate to expand in continuing to move this case forward and ultimately bring it to trial. So I did make that overture around the time of the holidays, so several months ago now. I have not heard anything further on that, but I remain willing, open to that possibility if there is some kind of offer, proposal in line with that. That might be something my client would be willing to consider at this point.
Unfortunately, as you know, my client was pinned down in a federal district court case, which involved a dispute with his former 50-50 partner. And so I was not at liberty while that was in progress. And there are still claims against the former partner. But nevertheless, Mr. Fecko and his client have their contract and they have their alleged guarantee. We're at a disadvantage over here on documents and information, but nevertheless, I propose. I don't have any authority today to settle the matter. All I can offer is, unless you set it for bench trial, a mediation, an arbitration, a facilitation. Pick your poison to try to resolve the matter. I'm sorry. I don't begrudge. The 30 grand is a lot of money, including attorney fees, but this is for both of us to be conducting a bench trial in Gaylord. I'm just talking out loud. Doesn't make a whole lot of sense.
all right. Well, I mean, I think these are discussions that you and Mr. Fico should have off the record. I don't think that really has a lot to do with me.
Okay.
So my view is I want to get this case resolved one way or the other. If having a bench trial date on the calendar will spur some discussions and potential settlement of the matter, that's great. If it doesn't, then we've got a drop dead date where everybody will be here in Gaylord and we can get things resolved. I only have one volume of the file with me at the bench here. Mr. Fico, was there a jury demand or is this going to be a bench trial as Mr. Norton has suggested?
There was no jury demand from plaintiff. I don't recall seeing one attached to the answer.
No jury demand from defendant. It'd be bench.
All right. So Mr. Fico, how many days do you think we would need to set aside for this matter?
I think this is a fairly straightforward contract issue, no more than 1 day that I can.
Okay. All right, Mr. Norton.
No more than one day.
Okay. And Mr. Fico, how far out would you want the court to set this for you to be adequately prepared?
Just take a look at my calendar here. I realize this case has been pending for some time. But if we are going to do this, I would say at, I don't know, 30, 45 days, somewhere in mid
Okay. Mr. Norton?
May, early June, somewhere in there.
Okay.
Well, first of all, I'd like to, so the court is, my oral motion to have a court-ordered mediation, facilitation, arbitration is not considered, and so we're just gonna set it for bench.
Yeah, I mean, at this point, this case is old enough. I'm not going to start ordering you guys back to a mediation or some other ADR. If the two of you reach some type of agreement by stipulation, you want to participate in that, I'm more than happy to allow that. But at this point, my goal is to get this matter resolved. And my role in doing that is getting a trial date on the calendar that I will not adjourn, absent the parties wanting to try to settle this, but otherwise.
Understood, Your Honor. Okay.
So, if we set this for 90 days out, Mr. Norton, is that enough time for you to be ready?
Yeah, it is, Your Honor.
Okay. So I think realistically, knowing my docket as I do now, here in Otsego County, I think 90 days is probably a realistic timeline to be able to get this set for trial. So we'll set it for a one-day bench trial in that time frame. I will set it for one final status conference shortly before that trial to address any issues that may arise. But otherwise, that's how we'll go forward. As I said, if the parties agree that they want to participate in some type of binding or other settlement process, I'm certainly open to that. Because I agree, given the amount of money at stake that you two have both articulated here, it seems like this is a case that could and probably should be resolved short of the expensive trial. So,
Will the final settlement?
We'll have a date to get it resolved, and we'll go forward from there. And I'll send out those dates to both counsel.
Okay.
Point of order, Your Honor. Will the final conference be via Zoom or in person?
It'll be by Zoom.
Okay.
All right. I appreciate that. And the trial date you estimate roughly 90 days, so somewhere like early July.
I would, yes, yeah. Okay. All right. Thank you. That's all I have. Again, I'll send those dates out to both of you, and you're both free to disconnect.
Very good. Thank you, Judge.
Thank you, Judge.
Okay, Mr. Wenzloff, are you able to hear me okay?
Yes, Your Honor.
Okay. We're on the record now in North Plains Area Credit Union versus Gordon. This is file number 2419755. The record should reflect that Mr. Wenzloff is present today by Zoom video. This hearing was set for 2 o'clock. It's now 2:14. I don't see anyone else appearing on this file today. This is set for a status conference. Mr. Wenzloff, can you tell me where things stand on this file?
Yes, Your Honor. I did talk to Mr. Borden a couple weeks ago, and I think this matter has been mostly resolved. I actually sent him a proposed consent judgment with, terms and whatnot. That was mailed probably last week or the week before. I haven't got it back yet. I haven't heard anything, but he did suggest to me on the phone he was going to sign it. And unless he had a problem with the actual terms or changed his mind, I don't anticipate him not signing it. So that's kind of where things are right now.
Okay. So it's settled, but you still waiting on the closing documents from the defendant?
Yes, Your Honor, that's correct.
Okay. So I'm going to set this for a control date status conference at 60 days out. If you receive that back from him, I'll look for dismissal and sign that. We'll take that status conference down. If not, then I do have a next date out there where we can check in. If it hasn't been finalized by then may need to look at other mechanisms to get the case closed. So do you have any objection to that?
No, yeah, I think that works fine for me.
Okay. So I will put that into an order. The court will send out that control date status conference notice of the date and time of that at about 60 days. And we'll go from there. Thank you. You are free to disconnect.
Thank you, Your Honor.
Okay, counsel, we'll go on the record in Richter versus Boiac. This is file number 2419878. If I could have counsel put your appearances on.
Good afternoon, Your Honor. Matthew Koss appearing for the plaintiffs.
Good afternoon, Your Honor. Brad Benz here on behalf of defendants.
Okay. Counsel, this is set for a status conference today. Mr. Koss, on behalf of plaintiffs, can you tell me kind of where things are at this stage?
Plaintiffs are, I have two elderly women who unfortunately sustained pretty good brain injuries in this case. So plaintiffs are ready to proceed with any discovery requested. We've sent written discovery responses, not been asked for their depositions as of yet. But my ladies are, still just treating and proceeding forward best they can. They're stuck in Gaylord with the storms too, so we've been keeping an eye on them.
All right. What would you like to suggest for scheduling going forward? It looks like the last time we had a status conference, maybe everybody wasn't in the case yet, or there were some changes to parties. So this in terms of a period for discovery, Mr. Koss.
And I do. So we recently added, I believe in this matter, a PIP claim for one of the plaintiffs against State Farm, and I don't think State Farm's here right now.
No, they haven't signed.
And I'm pretty sure they've appeared, so. But as far as discovery goes, I'm comfortable with whatever council needs. I mean, we're ready to move forward. And then following discovery, I would suggest that the parties facilitate, if we're unable to resolve prior to that.
All right, Mr. Benzinger, anything you wanted to add in terms of updates? And then what are your thoughts for scheduling dates going forward?
Yeah, nothing as far as updates, Your Honor. We haven't, I know there's been written discovery. I can't access my files at the moment still. We're offline, and have been for the last week. We also haven't got a ton of medical yet, I don't think, and other than written discovery being exchanged, really not much has been done, I don't think, with the understanding, I think that State Farm did come in and hopefully do those things one time. I think if we had a, discovery in that, I wish I had the date that this was filed and we had our last conference, but with State Farm coming in, that 150 to 180, and based a lot on what I'm hearing from counsel, if the allegation is, brain injuries, I anticipate neuropsychs and having to do some, considerable workup with potential IMEs.
Okay, so if we set discovery to remain open for the next 180 days, with mediation to occur during that period, Mr. Cost, do you have any objection to that?
None at all, Your Honor.
Mr. Benzinger?
None, Your Honor.
And do you all think you'll be able to agree on the mediator?
Yeah,
I would think so.
Okay. So I'll just put in the order that the parties to agree on a mediator, notify the court of your choice in writing within 30 days. So you have 30 days to select a mediator. And then what I typically do is set this for a status conference at the close of discovery, see where we're at that point. Any objection to that, Mr. Koss?
No, Your Honor.
Mr. Benzinger?
none, Your Honor.
It looks like the attorney I have listed for State Farm is Ray Littleton. Have either of you had any contact with him?
I
No.
just was emailing with him on another file. He just sent me an email 2 minutes ago. I didn't realize it was Ray. I work with Ray all the time. I can pass this information along with him. I assume he would have no issue with it. He would probably ask for whatever discovery you would give us and then probably go facilitation afterwards. But if the court would like me to do something else, I'd be happy to.
No, that's fine. And he'll get a copy of this order. So if he has any objections, he'll have an opportunity to file any objections to the scheduling and we can address those. So, all right. So I'll put out the order. The court will send out notice of the date and time for that next status conference. Mr. Koss, any other things I can address for you today?
Nothing for Your Honor. Thank you.
Mr. Benzinger?
Nothing, Your Honor, other than Matt. We don't have much of anything here, so I'll get with you as soon as we get everything back and get with the mediator.
Yeah, I'll send you. I mean, if you've not got it, I'll send you everything I have at least.
Yeah.
And we'll send. I'll send an email around with you and Ray on it. Let Ray know what happened today and throw out some names for a facilitator.
Sounds good.
Okay, thanks. You're both free to disconnect at this time.
Thank you, Your
Thank
Honor.
you,
Have a
Honor.
good day.
Thanks, Matt.
Everybody stay safe up there. I know the weather's been awful, so take care.
It's been an adventure. Thank you.
Yeah.
Okay, looks like we have parties connected, so we'll go on the record in Hay versus Hay. This is file number 2519984. Mr. Blumberg, you're appearing on your own behalf today, is that correct?
Yes, Judge.
Or, I'm sorry, not on your own behalf.
I need somebody to represent me.
You're appearing on behalf of Miss Hay.
Yes, that is correct.
All right, Mr. Hay, you're appearing on your own behalf.
That is correct.
Okay, all right. And Mr. Hay, you're employed by Treetops, is that right?
That is correct.
Okay, and you were in the men's league when that was out there, the golf league?
Yes, sir.
Okay, so Mr. Bloomberg, I just want to disclose that I did play in that golf league, and I played a number of rounds with Mr. Hay as part of that. And I think at one point he gave me some advice on my lawn. But I haven't interacted with him since then, but I want to disclose that prior contact to you.
Judge, I'm more concerned about whatever advice he gave you about your golf game.
No advice on that. I could definitely use it, but okay, so this is set for a status conference today, and so I'd like to set some dates going forward. On behalf of the plaintiff, Mr. Blumberg, do you have any suggestions for scheduling?
Judge, I don't think that's going to be necessary. I've met with the parties. They have come to an agreement on all of the issues. I have a proposed draft judgment that has not been circulated yet. But what I would like to do today is to perhaps preserve the proofs, and we can get a judgment entered timely fashion.
Okay. Mr. Hay, would you agree with what Mr. Blumberg's had to say?
That is correct.
Okay. So Ms. Hay and Mr. Hay, if you could both raise your right hands, please. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
Okay, thank you. You can both lower your hands. And Mr. Blumberg, if you'd like to proceed with testimony from your client.
Sure. Mitzi, can you state your full name for the record, please? Mitzi, can you hear me?
No, I can't hear very well. It's in and out. I apologize.
Well, let's see how far we can get. Can you state your full name for the record?
Yeah.
I know you can.
Yes. Mitzi Maurice Hay.
Okay, and you are the plaintiff in this action for divorce. Is that correct? Mitzi, can you hear me?
Yes.
Okay, I asked you whether.
Yes. Can you hear me?
Yes. Are you the plaintiff in this action for divorce?
Yes.
Okay. Is it true that you filed a complaint for divorce, and in it you alleged that on May 16th of 1998, you married Douglas Hay in Benzie County, Michigan?
Yes.
And that ceremony was performed by an individual who was authorized to perform marriages. Is that correct?
Yes.
Okay. You alleged in your complaint further that you had been a resident of the state of Michigan for at least 180 days preceding the filing of your complaint. Is that true?
Yes.
You further alleged you'd been a resident of Otsego County for at least 10 days immediately preceding the filing of your complaint. Is that true?
Yes.
There are no minor children born of this marriage at this time. Is that correct?
Correct.
Okay. You alleged in your complaint that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed?
Yes.
And is that true today?
Yes.
Now, you and Mr. Hay and myself have met on a number of occasions to discuss a settlement of all the issues. Is that correct?
That's correct.
And you believe that you and Mr. Hay have in fact come to that agreement as it resolves all the property issues in this case?
Yes,
Okay. One of the things that you've asked for in your complaint is that your maiden name of Leica be restored to you. Is that correct?
yes,
Okay. You and Mr. Hay have agreed on the issue of spousal support, wherein he will pay you $1,500 a month for 108 months, spousal support to be paid by the 7th of each month. Is that correct?
yes,
And that spousal support is non-modifiable. I want to make sure you understand that in the event that Mr. Hay should win the lottery and becomes a multimillionaire, you're not going to be able to come back to court and ask Judge Mertz to review the issue of spousal support. Conversely, if he loses his job, he still has this obligation to pay. Is that your understanding and agreement?
yes,
Okay. And in fact, Mr. Hay has agreed to maintain a life insurance policy, naming you as a beneficiary to act as security for the spousal support obligation. Is that your understanding as well?
yes.
Okay. Rather than going through each and every item of the property settlement, I would simply ask you at this point, have you had a chance do you have an understanding as to what the agreement is?
Yes,
And you believe that agreement to be both fair and equitable?
yeah,
Are you asking the court to adopt this proposed judgment of divorce, which incorporates this property settlement agreement?
yes,
Now, I have to ask you this for the record. Are you currently pregnant?
no,
Okay. And again, are you entering into this agreement of your own free choice and free will?
yes,
Has anybody forced you or threatened you in any way to agree to the terms of this property settlement agreement?
no,
You understand that if this agreement wasn't reached, that there could be a trial in this matter, and all of these issues that we've resolved today would be decided by the court. You understand you have that right?
yes,
Is it still your understanding and agreement to abide by the terms of this settlement agreement?
yes.
Okay, thank you. Judge, I have no other questions.
All right, thank you. Mr. Hay, did you hear all the questions that Mr. Blumberg asked of Ms. Hay?
Yes, I did.
Were you able to hear all of her answers?
Yes, I did.
Do you have any reason to believe that any of the answers that she gave were untrue?
No,
In terms of the property settlement agreement, did you hear those terms as they were stated by Mr. Blumberg?
yes,
And do you agree to abide by those as well?
yes,
In terms of the spousal support, as Mr. Blumberg indicated, it sounds like it is non-modifiable, so you understand that you would not be able to come back later and ask the court to change that?
I understand.
Okay. In this case, it sounds like Mr. Blumberg was retained by Ms. Hay. You understand that you would also have the right to have an attorney?
I understood, yes.
Okay, and that if you wanted to consult with an attorney about the terms of this agreement, and you indicated that to me now, that I would stop this proceeding and give you an opportunity to do that before we finalize the divorce?
No, we agreed on everything.
Okay, so you feel comfortable going forward?
Yes, sir.
Okay. All right, thank you. Mr. Blumberg, did you have any questions for Mr. Hay?
I would just ask Mr. Hay, now you have represented yourself in this matter. You were aware that at all times I was your wife's attorney, is that correct?
That is correct.
And to the extent that legal advice may have been given to your wife, none of that was directed towards you. I have not advised you in any way, is that correct?
That is correct.
And again, as the court pointed out, once this judgment is provided to you, you have the opportunity to have it reviewed by another attorney if you wish. You understand that?
I understand.
Let me just ask you one last question, if I may. Given the negotiations and the agreement that apparently has been reached, you believe those to be both fair and equitable?
I do.
Thank you. I have nothing else, Judge.
All right, thank you. The court finds based on the testimony of both parties that the statutory grounds for divorce have been met. The court will grant the divorce on the terms as indicated here on the record. The court will sign the judgment once it's been presented. Anything further from your side, Mr. Blumberg?
I don't believe so. Thank you.
Mr. Hay, did you have any questions at all?
No, sir. Thank you.
Okay, thank you. That's all for today. All parties on this file are free to disconnect.
I did not hear the last part. I apologize.
Sure, Ms. Hay, you're free to disconnect at this time.
Okay, thank you.
Hello.
Okay, looks like we've got everybody connected. We'll go on the record in Ryman versus Johnston. This is case number 2319394. Looks like Mr. Ryman's connected, as is Mr. Couch on behalf of the defendants.
Yes, good afternoon, Your Honor.
Hi, so we're on the record here today for motion. Mr. Ryman filed a motion for sanctions. I did have a chance to review that motion. Mr. Couch, I did receive your response, so I had a chance to review that. Mr. Ryman, anything that you wanted to present today by way of oral arguments toward your motion?
Yes, Your Honor. Thank you. I'd first like to note that in Mr. Couch's response, he didn't really deny any of my assertions or allegations. He just basically said, well, Mr. Ryman called Wolf one time when he said he didn't receive the notice of the January 6th pretrial on a different case. And also, even if we didn't serve him or we can't prove we served him, we did file it. So that should be sufficient under the court rule. It's not sufficient under the court rule. And Your Honor, the reason I hearken back to the original answer to the complaint is that they said the same thing at the time. Okay, we didn't serve it on you properly and timely within the court rule, but we did file it. So therefore, you're not entitled to the default, which the court agreed with. I just want to note that it's the same tactic, and it's continued throughout this case. And I'll touch on that with the request to admissions a little bit. I didn't include all of my correspondence with counsel to show that it was really a deliberate deception. It's as clear as I can be about it. So I'm asking for relief, Judge, for discovery sanctions. And although Mr. Couch says that the case law supports that the court shouldn't enter a default without a prior discovery order being violated, I would note that I cited the court rule, and the court rule does include language for failing to provide discovery up to and including the sanctioned default. I would ask the court, if you do not consider that, to consider the other remedies I requested, including an order extending discovery. And I would ask the court to enter a specific order requiring the Johnstons to produce themselves for their own depositions, as well as their experts. And I would ask the court to consider including in an order that they be required to do that at their cost. I have been through the ringer through no fault of my own, Judge. You'll see, I think, in the exhibits that I attached, there's only one party that's obstructing and obscuring. I have tried to do a smooth discovery with Mr. Couch and his colleagues dating back to September of 2023. And I've just been ignored. So after Mr. Couch first came into the case in March, this is referring to the depositions, Your Honor, he said he couldn't do them for 60 days. And I apologize, in my motion, I said that he agreed to March 9th. He actually agreed to May 9th. So the court extended discovery. We set the defendant's depositions and my deposition by agreement for May 9th. On May 8th, Mr. Couch had his secretary email that he was canceling those. He needed to cancel. So then I went through the process of formally setting them by notice of deposition. I did so on June 19th, on July 15th and 16th, and eventually the latest round of disrupted discovery ended up having me set them for November 1st to try to get them in before discovery ended, because there was a dispute over whether or not they provided other discovery, which I didn't learn about till the last week of October. So I asked Mr. Couch simply to agree, like me and Mr. Carey did on the related Prather case, to just leave discovery open and we can take it as necessary. When he didn't respond, then I noticed the Johnston Depps and their experts, and he just simply ignored them. He didn't seek a court order. He didn't seek intervention. Just like with the June and the July dates, he did not receive the court's permission to skip the Depps or a protective order. He just skipped them. And that's what got us past the point of discovery. And Your Honor, I made a mistake in not raising this previously to the determination on the motion for summary disposition. I did believe that with the witnesses I presented, we would get past that and then we could address all this. And I just didn't want to confuse the issue. But it is something in fairness. I should have been able to provide the Johnston statements, and I should have been able to ask their experts, hey, did you know that one of my claims is that they changed my driveway? And yes, right now it angles to my house and that's why I'm flooding. But did you know that previously the witnesses stated all of the water flowed in the other direction away from the house? And one witness has testified that she watched Mr. Johnston change it to the other direction and change the flow of the water by her own eyewitnesses. I should have been able to ask the experts that. That would have been helpful to the court on that issue. So that is why the depositions weren't taken, Judge. They just didn't honor the notices, and they obstructed and obscured my efforts going back to September of 2023. With respect to the request to admit, this is a mandatory court rule. The punishment or sanction for violation of discovery in other respects is left to the discretion of the court, and it's anything from an order about discovery all the way up to default. As to request to admit, those are a special kind, and the court says that they are deemed admitted unless they're responded to within 28 days. The second part of that rule says they have up to 42 days to serve plaintiff if the request to admission are served with a complaint. So as I stated in my motion, that kind of makes it clear what they're talking about is response, is filing and serving, that's what's considered response to request to admit. And here we go with, again, what I think is an obvious intentional effort by Mr. Couch to make it appear like he served me, but he knew that he did not. And what's the end game there? The end game was he also filed a motion to strike my request to admit, and noticed it for hearing. And throughout that time in early October, Mr. Couch and I are having communications, and I'm sort of feeling him out as to why he didn't answer them. That shows that he knew they were not answered, or I was not aware that they were answered. Then we have Mr. Couch's paralegal, Brian Stevenson, emailed me on September 25th. Now, this would be 2 days prior to when they're deemed admitted. And Mr. Stevenson provided me the expert report that the court's aware of, and again, apologized and promised that the rest of their experts' reports, which I've still never received, were forthcoming. Those have been promised to me. I'm entitled to them, even under initial disclosures, but certainly throughout discovery and my formal discovery requests, I still don't have those expert reports. I cooperated. I got them in on May 2nd to inspect my home, and they're just simply not providing discovery. But Your Honor, with the request to admit, this goes a little further because Mr. Stevenson didn't mention the request to admit on September 25th. Mr. Couch in none of his October communications until finally October 17th, after I said, well, look, you didn't respond. They're all deemed admitted. Where do you want to, where do we go from here? Do we want to set a hearing on damages? That's when he finally said, oh, we mailed them on September 20th. I've shown the court, Mr. Couch hasn't responded to this at all. I've shown that on September 20th, they mailed me a single small envelope containing 3 pages, 1 stamp for a different case. That would have been that time frame, but that's all I received. I did follow it up, and they apparently were aware of it because the court clerk told me that they subsequently received that document 6 days after it was mailed to me, and that their procedure was to send that back. So by all accounts, Mr. Couch was aware that he didn't serve me. The other thing of interesting, and I did note this, Your Honor, I appreciate that I already told you this in the motion, but this is the only document he claims to have ever mailed to me and not emailed to me. Now, he says something in his response that, oh, Mr. Ryman, he's improper and he should pay attention, and he asked to be served by email. That's not true. Very early on in the case, I suggested under the court rule, why don't we all stipulate and sign an agreement to do service by email as opposed to service by mail under the court rule. It has to formally be changed by an order of the court with stipulation of the parties. Not one of the attorneys responded to me. And yes, we have been operating when there's been an acknowledged service of email, that we have been operating with that. but I have been sending my documents by regular mail under the proper service and by email as a courtesy. And that's all I asked for them to continue with as a courtesy, send me them. As to Mr. Couch's claim that I cried wolf on the January 6th incident, Your Honor, that was a mistake on my part. We did receive 2 notices of pretrial, and that was brought to my attention by my mail neighbor who opens my mail, because I get the notice that says I received 2 notices. He opened them and said, "Oh, they're both notices for pretrial with Judge Mertz. One is on the morning and one is in the afternoon of January 6th." He did not know and notice the different caption for the insurance case. So I hadn't recalled this when it came on the record. I was surprised that I missed it. I did call the court clerk when we noticed that confusion, and the court clerk advised me that it was set for the afternoon. And of course, they didn't know that I didn't notice the different caption for the morning one. So that was completely my fault, but that's what happened on that. I received the notice delivery, I received the notice delivery from my mail service. We just made a mistake as to it. Under the court rule, I believe, Your Honor, because they didn't file and serve me, whether you find it was negligence or intentional, those should be deemed admitted. And that is every aspect of the case, every aspect of it, except the amount of damages. And those have been filed, and I do believe that I'm entitled to that relief. Finally, Your Honor, I've also asked for default, and I would ask the court to consider it based on the numerous improper filings and violation of discovery and preclusion of any discovery at all throughout this case. The default should be considered. But I want to take the court back. The reason I started with their answer, where they got cute and said, well, we filed it, we didn't serve it, but we forgot, or we didn't realize it. Your Honor, that answer is not signed by any lawyer. Now, this is very basic pleading and practice in the court rules and common lawyer 101. The court rules say, and that's 1.109E2, it's cited in my motion, every document must be signed, every pleading must be signed. They go on to say in 2.508, the jury demand can be attached with the answer, and in this case, a counterclaim, which was also not signed. At the end of the answer, then they put the counterclaim, and then they put the request for relief, and then they put the jury demand, and that was electronically signed. 2.508 says the jury demand is a separate document from the answer. So, and it's on a separate page. They signed the jury demand. They did not electronically or in any other way sign their answer. And the court rule says, that's still 2.109E3, the court shall strike that pleading unless it is promptly signed after it's brought to the attention of counsel, which I attached Exhibit 22. When I was not served with the answer, I went to the courthouse, made a trip up there, and I noted that Ms. Lehman did not sign it. So I sent her the email, and it's attached, and it says, you know, I noted you didn't sign it as the lawyer. And, you know, I kind of respected that because the answer is all false. There's lots of false statements about the stone channel, et cetera. But that still hasn't been filed. And that it's way past. It's more than a year and a half past. It's time to be served properly, signed properly. It should be stricken, and the default should be answered or entered for failure to file an answer to this case. And I attached as my final exhibit a proposed order that strikes the answer and enters a default. So based on all of that, Your Honor, I've been put through the ringer. I have not done anything improper. All my services have been proper. Theirs haven't. They didn't answer the request to admit. They didn't serve them. They didn't permit any depositions of the Johnstons or the experts, and they played it right out to the end. So I didn't have enough time after November 1st to properly notice a motion before discovery expired. And I didn't want to, you know, do something outside of the allowed court rule notice provisions. And finally, they haven't filed an answer. They filed a lot of improper pleadings. Default is the proper remedy, and I would ask the court to enter that.
All right, thank you. Mr. Couch?
Thank you, Your Honor. I'll be very brief. Mr. Ryman is objecting to matters that were settled by the court when partial summary disposition was granted to the Johnstons on the water damage claims. As I argued to the court, this instant motion is nothing more than a motion for reconsideration by a different name. Mr. Ryman did not timely file his motion for reconsideration. And so now he files this motion for sanctions, or so he calls it, asking the court to essentially grant the same relief. At the end of the day, he's also seeking summary disposition, so he clearly has not provided the defense with enough notice. But Your Honor, I'd like to very briefly take the court back to November of 2024. I filed a motion to strike the plaintiff's request to admit, because if the court recalls, he did not also, pursuant to the court rules, file them with the court. And the court went through the arguments both ways. I was asking that they be stricken because Mr. Ryman didn't file a copy with the court pursuant to the court rules. And at that hearing, the court said, look, you eventually did file service, and the defense answered, so we all moved on. And Your Honor, the court file reflects Mr. Ryman served them on us on August 30th. We actually answered them a week early, Your Honor. My secretary emailed a courtesy copy to Jennifer O'Rourke at the court. And the reason why they were mailed was because they were going back to everybody a week early. And we checked the court register of actions. It shows that they were filed on September 24th. Your Honor, Mr. Ryman, again, is complaining about many things that should have been addressed while discovery was open. He had a habit of arbitrarily picking days for depositions that I communicated to him were not good days for my clients. I asked him to work out a day with my secretary. He didn't do that. And then what he would do was wait until the very end of discovery and notice up depositions without the requisite time under the court rules. So for the several reasons set forth in our response to his motion for sanctions, we would ask that the court certainly deny the relief that he's seeking and hold the pretrial conference on the remaining claims that we just filed our second motion for summary disposition that will be heard in June.
All right, thank you. It's your motion, Mr. Ryman. Anything that you wanted to say in response?
Yes, Your Honor, I'll just answer a couple of the accusations of Mr. Couch. I did file my request to admit. There is no time frame set in the court rule for that filing. And I filed them with the same filing that I did the Prathers, and the Prathers were 3 weeks behind because it took me that long to do them. But I would note those were filed 6 weeks before the hearing on the motion to strike for not filing. And Mr. Couch was aware of that. The depositions were set by me eventually at the end of November after I had been throughout the month of October asking Mr. Couch about his discovery responses and requests for dates. When I never got any, I finally just set them. That's the same with the experts. He never responded or gave me any dates. He wouldn't agree to extend discovery. And so I was coming up at the end of it and I said, well, I just got to set them. If you want to adjourn them and give me dates and agree that they can be taken in November, that's fine. I just wouldn't get any response from him. So that's why that was done at the last minute. And that started back in February. I attached the emails, February of 2023, where I was trying to take their deposition. Excuse me. So with respect to dates that Mr. Couch was not happy with, first of all, he gave me the the July 15th and July 16th dates I used. He picked those, and I picked the 17th for mine. He subsequently said, well, the Johnstons aren't available. I'm available, but the Johnstons aren't. And I said, that's fine. If you tell me what why they're not available, we'll work around it and pick any other dates. He hasn't done it. I asked in the request to admit that they didn't have anything else going or to tell me what it was, and they refused to answer it. So that's why they've never been reset. I gave Mr. Couch a 2-week window, and that's attached in my exhibits. Pick any day in those 2 weeks, and he refused to. So without getting them to agree to dates and canceling 2 dates that they had given me, I just picked dates out, 2 weeks in the future, and then offered to reschedule them if they gave me any conflict, and he would never give me a conflict. So I did everything I could, Your Honor. Maybe I should have more forcefully asked for orders earlier, but I did not expect that even on the last in October and November, they would skip them. And I don't think I could anticipate that. And the next day, discovery closed. So I think it's reasonable. It doesn't cause any prejudice to any party to allow me to take those steps and then present that information to the court. Thank you.
All right. Again, I had a chance to review the written submissions by the parties, taking that into account along with what both sides have had to say here on the record today. The request for sanctions was made pursuant to the court rules covering discovery violations, as well as the court rules for signing improper, frivolous, or harassing pleadings, or those which have no arguable legal merit. So I guess first looking at the discovery issues, I have no idea, other than Mr. Ryman, it was apparently your tactical decision to not raise these discovery issues. Why we're addressing these in April now, after the court has heard and ruled on motions for summary disposition. These are all issues that should have been raised by way of motions to compel. In terms of the depositions, certainly at before, or I mean even after the close of discovery. It apparently, based on what you said today, Mr. Ryman, you made the tactical decision. You thought that your case was strong enough to survive summary disposition without compelling or seeking the court to compel those depositions prior to that point. Then you lose the motion for summary disposition on a number of your claims, and now you want to retroactively attack the discovery process. And you missed your chance. I mean, if this was going to be raised, it needed to be raised before the court heard and ruled on motions for summary disposition. I think there's some merit to Mr. Couch's point that this is really a retroactive motion for reconsideration by a different name, trying to attack what happened before the motion for summary disposition. In terms of the request to admit, same kind of thing. Like if you believed you had a basis for the court to find that the defendants had admitted liability on one or more of your claims, I have no idea why you wouldn't raise that at or prior to the motion for summary disposition hearing. But to lose the motion in the ways that you did, and then now try to claim that there were things that were done improperly before that, and now the court should reverse itself on its motion for summary disposition, order the discovery, and then essentially rehear the whole summary disposition issue. Number one, that doesn't make any sense. Number two, that boat has sailed, and you're a former attorney. You understand how this works. If you were a lay person, I could understand not getting the significance of those things in the order that things need to go in. But for you, there's just simply no excuse. And whether it was negligence on your part or a tactical decision, again, that boat has sailed. So I don't find any reason, and that's one reason. The other thing is, I think there is a lot of merit to Mr. Couch's argument that there were no orders compelling this, so they didn't violate any orders of the court. And I think that a violation of an order of the court compelling discovery would be required before the court could issue the kind of sanctions that you're asking the court to issue. Similarly with the pleadings, why now, more than a year after the responsive pleadings are filed, now you want the court to strike those again, way past the time where you should be attacking the pleadings, or where the court would consider granting you a default based on defects in the pleadings that's been out there for so much time. Certainly, if you believe you had an argument on that, it's incumbent on you to raise that argument in a timely manner. And to the extent that you haven't, the court would consider it waived. And again, I think it's disingenuous after you lose the motion for summary disposition to now try to go all the way back to the initiation of the case and attack things that happened then. Again, I don't think it's appropriate. I think any of those kind of arguments have long been waived. And again, I think you should know better. If you were a lay person, I might be inclined to grant some leeway there, but in this case, again, I don't find any reason to allow that. So the court finds that there just isn't a basis to grant any kind of discovery sanctions. There's certainly not a basis to grant a default based on some kind of defect in the response to pleadings that occurred at the beginning of the case. At this point, given the posture of the matter here today. The other thing that I would say is, and nobody's addressed this on the record, but I think it's important to address it. You know, Mr. Ryman, you make a lot of complaints about what the defendants have done in this case. You're accusing them of felony malicious destruction of property, insurance fraud and forgery, racism, putting statues on their porch reflecting racist themes. You're making these accusations against people. And I think it's important to acknowledge that because I think it's wholly inappropriate. And I can appreciate zealous advocacy, and I can accept that sometimes that kind of advocacy leads to some contentious statements and arguments and things put in print. But it's generally my philosophy, and it was as a practicing attorney and certainly is as a judge, that ad hominem attacks in general just are inappropriate when they're made against individual parties or against opposing counsel. They don't really have any place, in my view, in written or oral submissions because they just don't go to the merits of the case. They have nothing to do with the legal arguments, the legal issues, the legal claims that are made in most cases, and certainly not in this case. And the court has admonished both sides in this case early on, based on some of the what I viewed as contentious and unprofessional statements. And defense counsel, to their credit, has largely refrained from that, except I think when they feel they have to defend themselves based on the comments that you've made, Mr. Ryman. But every one of your written submissions, Mr. Ryman, includes personal attacks, both against the defendants and opposing counsel. And again, they don't have any relevance to your claims. They don't have any place in written pleadings. Certainly not an oral argument. And if you want to grind those kind of axes on your own time and using your own resources, that's up to you, but I'm certainly not going to allow you to use the court, use my docket, use pleadings filed in this court as a medium or a forum for you to engage in what I view to be inappropriate allegations and personal attacks that, again, have no bearing really on what's going on in this case. And I think they're inappropriate, and to the extent that they continue, whether or not the defense moves for any kind of sanctions, I think the court has the ability on its own motion to sanction that kind of conduct. And I find it completely inappropriate, and it just continues, and it appears to be getting worse given your statements, your accusations, which, whether true or not, certainly don't belong in this case. So the court certainly will consider sanctions to the extent that you continue to make those kind of personal attacks that are irrelevant to the claims. All of that being said, and overall, for all the reasons the court has stated, I find that the motion here should not be granted, and the court will deny the motion. I also want to address the motion for reconsideration that was filed pursuant to MCR 2.119. Whether or not it was filed in the correct timelines and served and so forth, the court is going to address it on the merits. I'm not going to hear an oral argument under 2.119 F2. There is no oral argument unless the court in its discretion allows that on motion for reconsideration. But I do want to address it today rather than issuing a written opinion, since we're all on the record. The motion for reconsideration, number one, raised as one of the issues that the video that was submitted as an exhibit in the motion for summary disposition, which the court reviewed. Mr. Ryman, in your motion for reconsideration, indicates that that was ex parte. It wasn't ex parte. It was filed as an exhibit to the motion for summary disposition. Everybody had a chance to review it. So I don't view it as an ex parte communication. I don't know why you would assume that the court hadn't viewed it. I review everything that's submitted by the parties as exhibits or written submissions. And so I don't think there's any reason why the court shouldn't have considered it, or why it was inappropriate for the court to consider it, or why the court should give you additional time to argue about it. Again, that was the date set for hearing. Everybody had plenty of notice. If you wanted to argue about that video, that would have been the time to do it. You attempted to do that at the end of the hearing, but you had more than an adequate opportunity. Again, as I indicated on the record there, the majority of the oral argument during that motion was taken up by you, that you had more than an adequate time during your period that was allowed for argument to argue against that. And my ruling was simply I wasn't going to then allow you to continue to add new things to argue about at the end of the hearing, and the court had to move on. In terms of the rest of your motion for reconsideration, it really is simply re-arguing things that the court did rule on expressly as part of its ruling motion for summary disposition. To the extent there were pictures or other things that you would have wanted the court to consider under 2.116G5, certainly the court has to consider any documentary evidence that's filed or submitted is the language. In my view, holding up pieces of paper to the camera where I really couldn't see what it was, and in doing so muted my ability to hear what you were saying. To me, that's not submitting pictures for the court to consider or other documentary evidence. Those are things, as I told you at that hearing, that should have been submitted prior to the hearing. Just like if we were in person for oral argument, if you're at the podium and you're holding up a picture for me to view from the bench, that's not submitting it either. If we were here in person, I would expect if there's something that the court needed to view, that you would submit it to the court, so the court had a copy that I could view. So I don't find that you holding up pictures in front of the camera or other documents was submitting them pursuant to the court rule. There was plenty of notice prior to that hearing, plenty of notice it was going to be by Zoom, plenty of opportunity for you to submit anything that you wanted the court to review or look at prior to that hearing. And you chose not to do that, and that was a decision that you made. So I think the court was appropriately not able to consider it because I couldn't see it. So again, the court doesn't, under 2.119, does not have to rehash its prior opinions. I'm relying on the record that I made and ruling on the motion for summary disposition. Your arguments and citation to the affidavits of your witnesses, I address those expressly on the record, I think individually. And so when I view your argument as a whole, it's really just disagreeing with the court's ruling, which is fine, and that's what appeals are for, and you're free to seek an appeal of the court's ruling, but I don't find that it points out any errors of the court as contemplated on a motion for reconsideration. So for the reasons I've stated here on the record, that motion is denied as well. Mr. Couch, I would ask you to prepare an order reflecting the ruling in the court today and submit that under the 7-day rule.
Thank you, Your Honor. I will. And I just have a quick question, a housekeeping matter. The court staff reached out to the attorneys a few days ago and indicated that the stay that the court previously granted with regard to the claim against the Prathers, apparently the clerk's office applied it to the entire case and then suggested that perhaps Mr. Ryman and I submit something additional clarifying that this portion of the case is not stayed. Would the court like me to include that in the order that I'm going to submit?
That's fine. I did address that today through staff with the clerk's office. They are going to correct the register of actions to reflect that only the Prather's portion of the case is stayed.
Okay. So nothing further needs to be submitted by the parties?
No.
Oh, thank you, Your Honor.
And then with regard to the status conference today, because there is another motion pending, I'm going to adjourn out the status conference until the date set for that motion hearing in June. And once the court's heard that motion and ruled, then we'll go forward from there.
Thank you.
That's all I have for today. All parties are free to disconnect on this file.
Thank you, Your Honor.
Thank you.
Yeah.
Okay, Mr. Blumberg, are you appearing on the Ferris case?
Yeah, we just lost power about 10 minutes ago, so.
Yeah, it flickered here too. I lost the TV, but everything else stayed on.
The Tigers are on. Were you watching that too? Or with
I wish, no.
Yeah, I don't think my client or his wife.
Okay. Do you want to just move that hearing out?
Well, I could kind of tell you where things are at. I mean, she's unrepresented. They've agreed on custody and parenting time. It's just some small property issues. I think we could probably have a judgment in 30 days.
Okay. So just for the record, this is Ferris versus Ferris, file number 2419904. Mr. Bloomberg's here on behalf of plaintiff, Mr. Ferris. Ms. Ferris is not present. But in terms of scheduling, I think that's reasonable. So I'll set it for a final hearing in 30 days.
Okay.
And you can go from there. Anything else on this file?
No, I don't think so. Thank you.
Okay. All right. Thank you.
Can we call it a day?
I think we can.
Okay. Thanks.
Thank you.
Bye-bye.
All right, one other case, Peters versus Peters, file number 2419704. That was set as a final hearing. Both of those parties have failed to appear in the past. However, for the record, I'm granting some leeway based on our recent storm and the lack of power that a lot of people are still experiencing. So we'll reset that one along with Ferris for a hearing next month. If neither party appears at that hearing, the court will dismiss that case. That concludes the court's afternoon docket. The court will be in recess until 9 a.m. tomorrow.